19 FC, People of the State of Michigan versus Jamarcie James. Mr. James is here for sentencing. Prosecution and defense was the pre-sentence investigation report timely made available to you.
Was, Your Honor.
It was, Judge.
And Mr. Prysak, have you had the opportunity to read the report and discuss it with your client?
Did, Judge.
Do you have any additions, corrections, or challenges?
Judge, looking, and I'm a little confused on his record, because when I scored the guidelines, it was indicated he had 2 misdemeanors. So I scored PRV 5 at 5 instead of 10. Brings his total PRV to 15, which puts us at level C. And then I had his guidelines at 30 to 50. I think originally when the prosecutor scored the guidelines, I think they had it at 36 to 50. So the midpoint is somewhere in between there, around 40 to 43 months. I know that probation has recommended 51 because they scored it PRV 5 at 10, and so that puts him up to D instead of C. So there's a little bit of discrepancy there. That puts him up at 51 to 85. So it makes the midpoint a little higher. So that's the only challenge that I have to the report, Judge.
All right, so if I understand what your objection is that you don't believe that PRV 5 is appropriately scored at 10 points, is that correct?
Yes, Judge.
Okay. Well, what I'm seeing is under prior record variable 5, you score juvenile misdemeanors and adult misdemeanors. His juvenile record indicates that he was convicted of retail fraud in the 3rd degree, May 24, 2015. That would be 1. There is a August 3rd, 2019, receiving concealing stolen property. That would be number 2 of misdemeanor offenses. Then in April 14, 2023, he had a 10-year felony charge reduced to misdemeanor, domestic violence. So that would be 3 prior misdemeanor or juvenile adjudications. Did you follow me on that?
Yes, Judge.
Okay.
I guess the reason I questioned it was it looks like on number 3, it says released from detention, hearing held, no further sanctions. So I didn't know whether they were counting that, whether that result would qualify as a conviction. And then it looks like number 107 was dismissed, and then I see the 2 was reduced to a misdemeanor. So that's why I had some question about whether it was 2 or 3. That was the main reason.
So what I looked at for number 3 was that he was charged with larceny less than $200 and receiving stolen property less than $2,000.
Yes.
I looked at the final charge being receiving concealing stolen property, which tells me that he was adjudicated on that case.
Right.
That he entered a plea, and that the sentence was he must have been in some sort of juvenile detention facility at the time, and he was just let out of juvenile jail. Not that the case was dismissed or consent calendar or anything like that. So it looks like all the indications that I have is that it was a conviction. What did you see from Judicial Warehouse?
I agree with you, Your Honor. That's the way I saw it too.
Okay.
In addition to that, under his adult record, number 2 of 7 was domestic violence, misdemeanor domestic violence. That should have been scored as well.
I was just calling the question with juvenile one, not adult, because sometimes they do strange things in juvenile court. And they say, well, okay, release you from detention is not going to result in conviction. And so that's why I was questioning.
All indications appear that it was an appropriate adjudication that would be scored under prior record grade number 5.
Yes, sir.
So any other additions, corrections, or challenges, Mr. Price?
No, Judge.
Anything that you want the court to consider?
Judge, I think the only other thing we need to address, I don't know how we're going to handle this, but there is some order of restitution in here. Looks like $1,316.57. From Freedom Chevrolet and Grant Tire Wholesalers. He's got some fines and costs. They impounded his car. It's been an impound since, that's May? Been an impound since May. So he can't pay the fees. He can't pay, transfer the title, anybody to get it out because it's storage fees and impound costs are way more than the value of the car. So Ms. Thompson had sent me a request as to whether or not he would want to surrender the vehicle. The idea being they would waive the fees and costs, then use that to apply it toward his restitution, and he basically wouldn't owe anything, he'd be done. And Mr. James agrees to that. So I don't know how we need to handle that. Maybe with an order from the prosecutor, something to that effect. But he didn't want to have that hanging over his head. So we agreed to forfeit the car, the Jeep, basically to cover all of those costs. There is some question about possible Indiana involvement that don't know whether Indiana is going to file charges and seek his extradition once he's in MDOC or not, but we don't need to worry about that now. But, so I don't know how the court wants to handle that issue regarding the restitution and fines and forfeiture of the vehicle.
Well, I don't want to handle that at all. Because that's not my problem. I mean, we've got a tow company that's owed the impound fee and storage fee.
Right.
So that's one entity that you have to deal with. I don't know what this car is worth. So if it's going to be forfeited and then sold, who's going to sell it? You know, how's the money going to be split between the tow company and the two victims? I mean, that's not my job to sort that out. I mean, it sounds like it may be a viable solution. It's just the execution of it is not up to me.
Yeah, I'm just a middleman here, Judge. I don't know how to. I guess I can get with the prosecutor's office and we can try to figure it out.
Mr. James, what type of car was this?
A Dodge Durango, all-wheel drive, 2017.
What do you figure it was worth?
I paid $13K for my.
13,000 for it. Okay. And how long had you owned it?
I had it for like 2 years now.
Okay. All right. No loan or anything on it?
No, it's paid off.
Okay. Sounds like there may be some value there, but maybe your attorney can work with the tow company and maybe it's assign the title to them, they sell it, they recoup their money, they pay, restitution goes, and I don't know, Mr. James, if there's any left, if he gets that money back, I don't know.
Judge, we'll work it out. At 8:45 this morning, I was having a conversation with my boss, like, the court is not gonna want to get involved in this.
Yeah.
I don't know if there's a lien holder on the vehicle that can complicate things as well. We'll get with Mr. Price, I can the police agency. The
Yeah.
court will have.
Okay.
Judge, we'll work on it.
Yeah. Okay.
I just brought it up because of the issue of restitution. That was kind of the thing. We'll take care of it.
Okay. Anything else that you want the court to consider, Mr. Price?
Judge, just that I'd ask the court to consider, as I questioned the guidelines, to go with our original sentencing agreement, which I think was, we thought the guidelines were 36 to 50, which would have been a 43-month sentence. It's still a pretty long time, Judge, rather than the 51. I know the probation department's at the low end of the guidelines, but we're asking the court to even consider going to 43 months. Thank you.
All right, and Mr. James, have you had the opportunity to read the report and discuss it with Mr. Prysock?
Yes, Your Honor.
Do you have any additions, corrections, or challenges?
No, Your Honor.
Is there anything that you want the court to consider?
No, Your Honor. I do have a question though.
Yes, sir.
I was asking about the SAI program.
Oh, yeah, I forgot that boot camp, whether or not he'd be eligible. I also indicate for the court, I had originally prepared a no contest plea, but he came in and pled guilty. It says in the report that he's not eligible for boot camp. I don't know why, because I don't know of any reason that he's not.
It may be the weapons charge. Might be one option, and number two is that if he's getting a sentence more than 36 months, that might also be a bar.
Yeah,
So I think those two things could stand in the way of the boot camp.
but I guess if he is eligible, we're asking that the court would then consider, if you're contacted by the MDOC, to consider boot camp. See what happens. They'll interview you in the MDOC.
At the court.
Determine whether you're eligible or not. If you are, then the other court, he's eligible, you have an objection. Okay. So I guess they can sort that out at MDOC, Judge.
Yeah,
Just ask
they let me know. They want to put as many people as they can through that boot camp program, because I think they would say that it's good for the offender. I think it's just cheaper. Instead of putting you in jail for 3 years, basically you get out in 6 months or whatever it is, and it saves them a lot of money. But they always send me a message and say, hey, can this guy go to boot camp?
Just asking the court to leave it open until, and if that time arises.
Okay. So anything else, Mr. James, that you want to say?
No, Your Honor.
All right. Mr. Walburn, any additions, corrections, or challenges?
No, I think the court's got everything.
Anything that you want the court to consider?
Nothing additional, Your Honor.
All right, so the court recognizes that the advisory guidelines in this case would suggest a sentence between 51 and 85. Mr. James, honestly, it probably could have been higher than that. They did not score you any points for this offense being part of felonious criminal activity involving crimes against a person, which they probably could have scored each one of these things as a financial transaction device violation. I mean, each of these attempted purchases, but prosecutor's not asking for that. The probation officer didn't score it that way. So I'm not going to score it that. I'm not going to interject that and score it that way, but your advisory guidelines probably should be higher than this. But you're a young guy. I don't know how you got wrapped up in this. When we talked at the time of taking the plea, I think you understood that I wasn't believing that no one taught you how to do this and you just kind of Googled stuff and figured it out. And I wasn't really believing that you were just doing this on your own and there's nobody else involved, because the police report says that other people went with you to pick up tires and you didn't do it by yourself. So I don't think that you were entirely honest with me at the time of the plea, but I can understand it. I mean, you're willing to take the fall for a long-term prison sentence without implicating anybody else. I guess that's up to you. But so all that being said, you're a young guy. I don't see a lot of these situations charged like this, and certainly it was borne out by the facts. But the court's going to exercise my discretion, since it's consistent with the advisory guidelines, consistent with the plea agreement in this case. You give the sentence of the court that you serve a minimum sentence of 51 months, a minimum to a maximum of 20 years with the Michigan Department of Corrections. There is a $68 state cost assessment, $130 crime victims' rights fund fee, $644.95 in restitution payable to Fremont Chevrolet, $671.62 payable to Grant Tire wholesalers. If you can settle that up with disposing of this vehicle, that's great. Otherwise, the courts can order that this restitution and financial assessments be collected through the inmate account and parole process. The other adjustment that we need to make is that you were originally set to be sentenced on November 18th, but we had to postpone it till today. So your jail credit should be updated from 183 days to 231 days. So we'll give you credit for the 231 days that you served so far. If the court gets a request for boot camp, I'll look at it at the time. Given all that you were involved in here, sir, if I were to approve boot camp, it would not be right away. They give me an option. I can say yes right away. They give me the option to say no way, or they'll say yes after a certain period of time. If I were to do boot camp, it would be yes after a certain period of time.
Yeah, sure.
We'll wait and see what they say. See if you're even eligible.
Yeah.
Okay. You do have the right to make an application to the conviction sentence. If you cannot afford attorney, the court appointed attorney will put you on the field. Request for lawyer must be filed in court within 42 days.